Y'all can have a seat. Feel like I'm back in the trial court.
May it please the court, my name is Craig Sanders. I'm counsel for the appellant defendant Jackson Radiology Associates. I'd like to reserve 3 minutes for rebuttal, please.
3 minutes.
Yes, sir. This case regards sufficiency of service of process. This is a Rule 9 appeal that this court granted in order to answer a singular question. Did the trial court err in denying Jackson Radiology's motion for summary judgment based upon its insufficient service of process? And we know from numerous cases, both from this court and the Tennessee Supreme Court, including the Hall versus Haynes case and the Roberts versus Hinkle case cited in the briefs, that a plaintiff has the burden to show that the person who was served was someone who can be served under the rules. We also know, both from cases from this court and the Supreme Court, that the rules regarding service are to be strictly construed and must be strictly complied with. That was not done in this case. The plaintiffs elected to serve Jackson Radiology via certified mail pursuant to Tennessee Rule of Civil Procedure 4.04 subsection 10. They had a complaint and a copy of the summons mailed to Jackson Radiology, and it was to be in care of the registered agent, Miss Sarah Edwards. Of course, being a domestic corporation, Jackson Radiology was statutorily required to have a registered agent, and they did, Miss Edwards. Well, you can look in the record on page 20-D, and that's the certificate, the registered receipt. The plaintiffs elected to serve via certified mail without restricting delivery to Miss Edwards. So there's two ways you can do it if you're going to send certified. You can do general certified, which means the mail carrier will get a signature, or you can send restricted certified, which means the mail carrier will get the signature of the person who's actually listed on the address. The Tennessee Supreme Court in the Hall versus Haynes case, which is cited extensively in the brief, specifically informed lawyers and parties that's the way to do it. The Supreme Court's exact words were, you can avoid this predicament by restricting delivery to the certain person. For whatever reason, the plaintiffs didn't do it. When the mail carrier delivered the copy of the summons and complaint, which of course is in an envelope, it was delivered to someone who worked in the reception area at Jackson Radiology, Miss Rita Autry. Miss Autry's official title was front office coordinator, and she testified in the case that her job duties included things such as greeting people, answering phones, checking people in, checking people out, and she was one of several people who did have authority to receive mail, including general certified mail. She testified she had never accepted service of process for Jackson Radiology. She would never do it, and when the mail carrier brought this particular, quote, stack of papers or stack of mail, she didn't even know what was in it. She further testified that she does not recall whether she gave that to Miss Edwards, the registered agent, or laid it on her desk. Sometimes she does one, sometimes she does the other. Miss Edwards also testified in the case, and she testified she oversees the non-clinical operations of several different locations and is in and out of the office frequently. When Miss Autry signed the return receipt, again on page 20-D of the record, her signature is very clear. It says Rita Autry. She also printed her name, Rita Autry. It's very clear that Miss Edwards was not the person who had received the attempted service of process. Pursuant to the rule, the plaintiff has to file that return receipt, which they did in this case, and it's in the record. So they knew at that point in time when that card came back that Miss Edwards was not the person, the registered agent did not receive that process. For whatever reason, the plaintiffs did not take any further action, even though pursuant to the rule itself, Rule 4.03 specifically states service is complete by mail if it's signed for by the defendant or one of the people authorized under the rule, which is a managing agent, an officer, or an agent overseeing the county. just a number of days after that, Jackson Radiology files an answer. It's undisputed in this case that they got notice of the case. They knew of it, just like in Hall versus Haynes, and they filed an answer. On page 1 of that answer are defenses number 1 and defenses number 2. One regarded Dr. Crossett, who was also a defendant in the case at that time. The other regarded Jackson Radiology. And the defense number 2 regarded Jackson Radiology was very specific. It said service of process is insufficient. The registered agent, Ms. Edwards, did not receive service of process, and the person that you served was not authorized to receive service of process. Despite receiving that answer, the plaintiffs, again, don't do anything else, even though the rule says, again, if the defendant or someone under Rule 4 doesn't sign, it's not complete, and you can attempt service again. That's explicitly in the rules, either by mail or by other means. Jackson Radiology then filed a motion for summary judgment and asked the trial court to dismiss the case based upon statute of limitations and statute of repose, because if service was insufficient, of course, under Rule 3, you can't rely upon the date of filing. The trial court granted the motion to Dr. Crossett, and that issue's not before the court today. But for whatever reason, the trial court denied the motion as to Jackson Radiology, even though Ms. Autry was the same person at the same time who received the complaint and the summons via the same mail carrier. What the trial court said, which is very similar to what the trial court ruled in the Hall versus Haynes case, was, well, and this is in the trial court's order in our case, Jackson Radiology got adequate notice, and the trial court found that Ms. Autry had implied authority to receive service of process because she received certified mail. That's contrary to the precise holding by our Supreme Court and this court in Hall versus Haynes. In Hall versus Haynes, you had a healthcare liability case similar to this, and the service was attempted a number of ways in that case, one of which was by mail, certified mail, just like our case. Mail carrier comes in Hall versus Haynes, and serves, similar to our case, someone in the administrative department who's one of several people who sometimes receives the mail, who doesn't know what's in the envelope, who later gives it to someone else. In Hall versus Haynes, it's clear that the Mid-South, the defendant in that case, the corporate defendant, did receive notice. And the defendant did the same thing in our case, raised it in the answer. And the trial court denied a motion for summary judgment in Hall versus Haynes. The trial court, relying on a case called Bowles versus Tennessee Farmers Insurance, said, well, if someone's authorized to receive certified mail, then they're authorized to receive service of process, because sometimes that's done via certified mail. This court reversed the trial court in Hall versus Haynes and stated that the Bowles case was, quote, erroneous, that portion of it. The Tennessee Supreme Court in Hall versus Haynes affirmed this court and agreed that simply having the authority to receive certified mail does not equate to having the authority to receive service of process. And the Supreme Court said in that case, for someone to have implied authority, you have to show, the plaintiff must show in the record that the defendant intended, there's evidence to show the defendant intended for this particular person to have the specific authority to receive service of process. In this case, Ms. Autry has given an affidavit. She's given deposition testimony. Ms. Edwards has done the same. It's undisputed she wasn't an officer managing agent at Jackson Radiology. She says, I've never received service of process. I wouldn't do it if I knew what it was. I'm not authorized. I welcome and greet people when they come in. I answer the phone. And she testified when the mail carrier comes in, usually what happens is he or she has a stack of mail, and they grab the first person they can to sign if it needs to be signed general certified. She said sometimes that's her, Sometimes it's the person sitting next to her. She said sometimes it's even people walking through who generally are in the back. The plaintiff argues, well, Ms. Autry had implied authority because she received certified mail, and you never told her she couldn't do it. In the Roberts versus Hinkle case decided by this court, same argument was made, and this court rejected it. If someone has implied authority to accept service of process, just because you never tell them that they don't, then how many people in an organization are going to be able to be served? Plaintiff cites a couple of cases to support their position, one of which is the Warren Brothers case. In that case, this court did find implied authority when an office manager was served with process for an individual defendant. And the key reason, clearly set forth in this court's opinion in Warren Brothers, for finding implied authority is that office manager had received service of process for that particular individual on other occasions, including, quote, 1 month ago. In this case, there's nothing in the record that says Ms. Autry had ever received service of process at any time or was authorized to do so. Plaintiff also cites the Rubio case, which is discussed by the Supreme Court in the Hall versus Haynes case. In the Rubio case, there was implied authority found by the court because the registered agent explicitly told his secretary, "You can accept service of process for me." That secretary then told the process server, "You can bring the complaint and summons to me." Much different case. Ms. Autry has testified no one has ever told her she can accept service of process and that she wouldn't do it. This court should do what the court did, what this court and the Supreme Court did in Hall versus Haynes, which is reverse the trial court and remand the case for entry summary judgment. Thank you.
Thank you.
May it please the court. My name is Nora Alexani Taub, and I am here on behalf of the plaintiff appellees. Your honors, this case presents a fundamental question. Was Jackson Radiology Associates properly served when their designated front office coordinator signed for certified mail containing our lawsuit and immediately delivering it to their registered agent pursuant to Jackson Radiology Associates' established procedures? The answer is yes. Under Tennessee's implied authority doctrine, Rita Autry was authorized to accept service on behalf of Jackson Radiology. The undisputed facts in this case show that JRA, Jackson Radiology Associates, designated Ms. Autry to receive all certified mail as her daily job duty. She signed for this lawsuit, which was served by certified mail, and delivered it unopened to the registered agent, Ms. Edwards. Exactly
Counsel,
as...
what facts do you have that Jackson Radiology specifically authorized Ms. Autry to receive service of process?
Your Honor, it's based on the fact that Ms. Autry received daily, sometimes multiple times a week, certified mail containing legal documents, and she personally delivered them to Ms. Edwards, who she had a working professional relationship with.
But you'll agree with me that under the Hall case, receiving general mail by certified mail, including legal documents, is different from receiving service of process.
Yes, Your Honor, I agree. And as Hall sets forth, receiving mail alone is not sufficient to accept service of process. But if we look at the Halls versus Haynes framework, and apply it here, we'll see that Jackson Radiology Associates was properly served through the doctrine of implied authority. Hall made 3 critical points when service is proper on a corporate agent through implied authority. First, quoting to a prior case, Hall recognized that service on an organizational defendant may be made on a representative so integrated with the organization that she will know what to do with the papers. The court further explained that generally service is sufficient when made upon an individual who stands in such a position as to render it fair, reasonable, and just to imply the authority on her part to receive services. And that's what Ms. Autry fits exactly. She was JRA's front office coordinator. She was specifically designated to receive all their certified mail and deliver it to the registered agent. She was so integrated with their operations that she knew exactly what to do, and that is deliver all certified mail immediately to Ms. Edwards.
Did she know specifically what to do with service of process?
No, Your Honor, but service of process is served through certified mail, and it's her testimony that she takes all that certified mail and delivers it to Ms. Edwards, the registered
That's true.
agent.
My point is, I think there's a marked distinction that Hall makes clear, that you can accept all the certified mail you want, and you can be appointed or impliedly allowed to accept certified mail, but it's different when you are accepting service of process. And the fact that you've chosen to serve via certified mail doesn't mean that someone who's appointed to accept certified mail is also appointed to accept service of process. I think those are two different inquiries, and I think you're going to have to show in what way she was designated specifically, not just to receive certified mail, but to receive service of process.
Yes, Your Honor.
And that's where I'm struggling to see the difference between this case and Hall.
Yes, Your Honor. The rules of civil procedure allow service to be effectuated through, I don't want to quote it, any agent authorized by appointment or law to receive service on behalf of the corporation. And the way that JRA structured the way they receive mail was granting Ms. Autry authority to accept and then deliver that mail, the service ultimately to Ms. Edwards. If you look at Hall, the second point that it made was that implied authority looks to the act or acquiescence of the principal rather than the actions of the agent. And what the focus is going to be on is that JRA created Ms. Autry's implied authority, not actually what Ms. Autry understood about legal technicalities. And then the third point from Hall is that it's the conduct or course of dealing between the principal and agent that's important for determining implied authority. And the court examines patterns of corporate behavior to determine if the agent has implied authority. And so if we're looking at Hall to our facts, in Hall distinguishing those employees worked in unrelated departments with no systematic mail responsibilities. Here, Ms. Autry was their designated front office coordinator and the specific daily responsibility for all certified mail, working directly with Ms. Edwards, the registered agent.
But again, and I hate to keep beating this dead horse, I don't see anything in the record that shows that Jackson Radiology gave her permission to accept service of process. In fact, I think the record says the exact opposite. She says they never told me I could accept service of process. I didn't really know what that was.
Yes, Your Honor, but the point is it's not about assertions, it's about conduct. It's a person with
She had never accepted service of process before.
I understand, but it doesn't rely on whether it's ever been done before. Otherwise, the doctrine of implied authority would not exist if it's never been done before. But what happened here is that she was designated to sign for all certified mail, including those that come through, like our firm did, with legal paperwork. And to take that, sign for it, and then deliver it ultimately to Ms. Edwards, the registered agent. She's precisely that type of representative that is contemplated in Hall, that she's so integrated with the organization to know what to do with it. And although not controlling, this court did find in Warren Brothers versus Santoro that there was implied authority when an office employee had previously accepted service and the principal acquiesced. Our facts here are even stronger. JRA specifically designated Ms. Autry for this function and maintained that system for years. as I stated earlier, Rule 404 subsection 4 permits service on any other agent authorized by appointment or by law. And through their systematic conduct, JRA gave Ms. Autry implied authority. Ms. Edwards testified that receiving all certified mail was Ms. Autry's job responsibility. It's not incidental. JRA specifically appointed her to this function and created that implied authority. They also established formal procedures for her to follow. Their normal process was for Ms. Autry to accept all the certified mail and deliver it directly to the registered agent. When asked, have you ever told Rita Autry she's not allowed to sign for you, Ms. Edwards said no. JRA never limited the implied authority that they created. And JRA's course of dealing confirmed it. Other employees prior to Ms. Edwards taking on that role had signed for lawsuits, and yet JRA never never modified these procedures. And if we're looking at the conduct or course of dealing, this is what represents the implied authority by conduct. Most importantly, what the facts show is that Ms. Edwards had never personally signed for any certified mail in the 2 years that she was the registered agent, because JRA structured their operations so that Ms. Autry performs this function with implied authority. And having given her implied authority to receive all the certified mail, JRA should not be allowed to claim she lacked authority at this point. Rule 404's requirements for an agent authorized by appointment has been satisfied here.
Let me ask you.
Yes, Your Honor.
In your certified mail to be served on a defendant, you did not include Ms. Edwards' name as a person who that notice was to be delivered to. Is that right?
I'll have to look through the record, but it was made out to Jackson Radiology Associates in care of Sarah Edwards.
You did have her name on it.
I believe so, Your Honor.
And then when you got the return and realized that she didn't sign for it, you didn't take any further action
No, Your Honor.
because you thought that was effective, because you knew she was a registered agent, you knew from the return that she didn't sign for it. Is that right?
Yes, Your Honor.
Okay.
What JRA is asking this court to do is to hold that when corporations structure operations so their registered agents can never personally receive mail, plaintiffs cannot rely on that corporation's designated procedures for service.
All right, let me just push back against that thought a little bit, because there were two fairly simple ways to achieve service here. Number one was just to personally serve the registered agent. Number two was just, if you wanted to do it by certified mail, do it restricted to only the registered agent. So I'm going to have to push back against this idea that they've intentionally set up their business to avoid service of process.
I understand, Your Honor. Although the case law does say personal service is the best method, the rules allow for service by certified mail. And although Hall was instructive that restriction is an option, it's not a requirement. Rule 4 does not require restricted service. And in this case, it wouldn't have mattered because Ms. Edwards had never signed off on certified mail in her 2 years of being in that role as registered agent. Your Honors, Ms. Edwards' testimony revealed that Jackson Radiology's Associates' deliberate system created that implied authority for Ms. Autry. All the mail that she received, all the certified mail that comes to her is received through Ms. Autry. JRA should not be allowed to create Ms. Autry's implied authority to receive service and then claim that she lacked the implied authority to receive them. When a corporation creates a system for handling legal documents and service of process and gives an employee the authority to receive them, that employee has implied authority to accept service under Hall's framework. This is not a case about curing defective service. It's about proper service under Rule 404, subsection 4, through implied authority. Under looking only at Hall's framework and examining the legal principles, service was proper when completed through Jackson Radiology's associate's agent with implied authority. We satisfied our requirements, and I respectfully request that that this court affirm the trial court's decision. I have nothing else unless you have questions.
Thank you, no.
Thank you, Your Honors.
I'd like to briefly address just a couple of things that were said. First of all, I'd like to point out another statement that's in the Hall versus Haynes case, which is certainly a controlling case in this regard. The Supreme Court in that case said, quote, Rule 4.04 subsection 10, which is the rule that we've been discussing regarding service via certified mail, was intended to provide plaintiffs with an alternate means of effectuating service. It was not intended to expand the class of persons who are authorized to accept service of process. And that's really what the plaintiff's arguing, that if I serve by certified mail, then it somehow expands the class, because anyone who can receive certified mail, whether it's a receptionist or somebody at the front desk, can do so. And that would be a very dangerous precedent to set. It would also be contrary to not only the Supreme Court's decision in Hall, but this court's decision in Hall, as well as other cases this court has decided. A couple other things. It was suggested, and has been suggested, at least in some statements in the briefs, that Ms. Autry received all the mail at Jackson Radiology. And that's just frankly not what the record says. It's not what she testified to. That's not what Ms. Edwards testified to. She was asked that question point blank, page 11 and 12 of her deposition, which is in the record in this case. Are you the only one who routinely signs for certified mail in the office? Her answer, oh no, sir, anyone can sign. It's whoever he being the mail carrier, can catch that's up there. She later said it's just whoever he, again the mail carrier, makes eye contact with and catch. It's also been suggested that Ms. Autry takes all the mail and personally gives it to the registered agent, Ms. Edwards. Again, that's just not what the record before this court says. These questions were asked in the depositions of both Ms. Autry and Ms. Edwards. Ms. Edwards was asked, did she hand, she being Ms. Autry, you the one for JRA and Dr. Crossett, or does she just hand you the one for JRA? If I recall correctly, both of these documents came around the same time, and I received both of them on my desk. So she doesn't recall for sure, but her recollection was they're put on her desk. Ms. Autry said she doesn't remember. Sometimes she puts them on the desk, sometimes she hands them. So that doesn't matter, because Hall says even if you do get all the mail, that's not enough. But factually, that's just, the record doesn't support it as well. Thank you.
Thank you. Thank you, counsel. Appreciate your arguments. Appreciate your brief. We will review the record and endeavor to get you an opinion at the earliest possible time. That concludes the call of the docket for this session of the Court of Appeals. We will stand in recess